In Texas, we do have a process of custody evaluations. In order to get an official evaluation, you have the court appoint the evaluator, and that evaluator has to have certain special credentials to be able to give any kind of a recommendation in a custody case. We have different levels of custody evaluation in Texas, and it can go from a simple, somebody comes in and they say, here's the state of each home for the courts, all the way up to the full-blown, they get into every detail of both parents' lives and will make an actual recommendation to the court about who the better person is to be the primary. They can even make some recommendations onto possession and access that would be in the best interest of the children. It can be very invasive for the parents to go through. It's also very helpful to the courts. One thing that I would caution when using those is they may not come out the way that you might want them to. So that is something that I would talk with your attorney about on whether or not that's a good idea to have one. It's often very difficult to prove what's happening in the other parent's home as far as abuse, neglect claims go. You want to be careful as a parent making a CPS claim or Child Protective Service claim that you're not very sure of what's going on, because it can backfire on you and they can actually use that against you as making a report just to get a step up on your custody battle, which is something you never want to do. You have to be very careful if you're going to record statements that your child's making, especially very young children. You don't want to coach them. So often this is very difficult because a child is going to say something and then you'll want them to repeat it so that you can record it. And I would caution you not to do that, because that could actually, one, taint the evidence, and two, traumatize the child. You want to make sure, if you think something's going on, get the child into some therapy and see if a therapist can actually get to the bottom of what's going on and if there is any abuse or neglect going on. Obviously, if the child has any marks on them, make sure you document. If you've been the victim of an accusation, make sure that you're also documenting the child's condition when you get them and before you take them back to the other parent, just to protect yourself. Try to do it in a manner that is not interfering with the child's natural activities. So you don't want to make them pose. Just take pictures of them doing things that they naturally do. And that way you're not traumatizing your child. In custody cases, we can actually have psychological evaluations ordered by the court. This can be a good idea if you believe the other parent may have a mental health condition that could affect the child, or if you want to establish that the child has some mental health conditions that might need to be considered whenever you're determining possession and access for each parent. It's a process where you apply to the court and you have to give the court good reason to make sure that there's an evaluation. Typically, when I ask the court for one, I will ask that both parties get evaluated as well as the child. We get a clear understanding of the parenting abilities of both parents as far as mental health goes. When I'm preparing witnesses to go into a hearing or into trial, I don't like to present a lot of the questions ahead of time. So I'll give them topics and we'll talk about how to present certain evidence and make sure I have a clear understanding of what each witness is going to discuss. And make sure that I don't ask a question that, one, they misunderstand, or two, I don't know the answer to. That can be pretty devastating for a question to get answered and then the answer is not something that's helpful at all. We want to make sure that they give clear answers, that you don't answer questions in a way that you think is going to be helpful, that you just answer them honestly, and that you don't want to sound coached. I have won many cases because the other side was overcoached and sounded like a robot on the stand. That's not what you want. So you just want to make sure that as you're preparing with your attorney, you understand the different areas that are going to be discussed. And while you may not get the exact questions, you want to make sure that you at least understand the topics that are going to be discussed and that you've communicated well with your attorney so that both sides, both you and your attorney, are understanding exactly what needs to come out in trial. So if you're looking at a high conflict divorce, reach out to us. We can answer your questions.